Thank you, Stafford. This will kick off the second half of this. I understand George Osborne is going to introduce a sequence of 6 speakers for their 20-minute segment. George?
Thank you. Good afternoon, Mr. President. George Osborne, pardon me, representing the California Association for Recreational Fishing. I want to make a couple of points as we begin. First, the department would have you believe that the court required them to complete an EIR on fish stocking statewide. That is not the case. A person or persons within the department made that decision on their own. Secondly, the department wants you to move forward with Phase 1 regulations and leave Phase 2, the disease part, to a later date because, frankly, no one, not even the department, can comply with the onerous requirements of Phase 2. Further, it is inappropriate to piecemeal these regulations. Either the regulations are ready for prime time in toto, or they are not. Clearly, they are not. Finally, you ask that industry provide you a credible analysis of cost to comply with the stocking permit requirements. CARF solicited bids from several recognized environmental assessment firms and selected Saphos Environmental. Saphos was neither the most nor the least expensive, but was chosen because of their impeccable credentials, and I'd like to introduce Marie Campbell of Saphos Environmental.
Do you have the PowerPoint presentation? Thank you. Good afternoon, Commissioners. My name is Marie Campbell, and our firm was selected to come back to some information about the cost of what it would look like for a party that wanted to implement and comply with the provisions of the measures. If you go to the next slide. So let me tell you a little bit about ourselves. Saphos Environmental is a recognized leader in biological resources management. We are a full-service environmental consulting firm. We have conducted hundreds of surveys for species listed as rare, threatened, or endangered, pursuant to both the federal and state Endangered Species Act. The importance being that those acts already provide the department with the authority to regulate activities that have an impact on listed or threatened species. We have expertise that encompasses all the applicable taxonomic groups that are addressed in the proposed regulations, including wetland and riparian plants, fish, birds, amphibians, and reptiles. We have one of the largest teams of biologists in a private consulting firm here in California. And we have the experience and have completed pivotal work in all 6 of major California water regions. If we go to the next slide. To assist us with this particular effort, we also collaborated with San Marino Environmental Associates. They're a recognized expert in aquatic biology. They've done pivotal work with California special status species, including the unarmored 3-spined stickleback, Santa Ana sucker, red-legged frog, and southwestern pond turtle. Their clients include the U.S. Fish and Wildlife Service, the U.S. Army Corps of Engineers, the California Department of Fish and Game, and the Los Angeles County Department of Public Works. They have extensive federal and state permitting experience, having done Section 7 consultations and pulled Section 10A incidental take permits for listed species, as well as Section 404 permits, Section 1600 streambed alteration agreements, and Section 2081 incidental take permits under the State Fish and Game Code and the State Endangered Species Acts. We can go to the next slide. So pivotal in Mr. Stafford's comments are this decision-making protocol that's related to both department stocking, and if you'll see in the 3rd line, there is a requirement to make a determination as to whether the affected water body is not only within the range of designated critical habitat, a process that's been gone through by either the state or the Fish and Wildlife Service to say these are areas that are critical for the continued existence of the species, but it goes much farther beyond that and says that is it in with the historic range of the species, and then we'll see that that's where this becomes very expensive and problematic. We go to the next slide. The next slide also has the same provision for private stocking of ponds, as to make a determination as to whether it's within the range, the historic range of any one of these 82 species that are called out in Appendix E to the proposed guidelines. We can go to the next slide. So here you have a composite slide that shows the California watershed system in the very light blue braided lines, which you see they're riddled throughout the state of California. We go to the next slide. This is the historic range for bald eagle, which is one of the 82 species, and you can see it encompasses most of the state of California. We can go to the next slide. This is overlaid with osprey habitat, also on the list of the species. Next slide. Willow flycatcher range, in the next slide. And then the red-legged frog habitat as well, reaching into Southern California. I'm not going to take you through all 82 of the species, but I think you can understand the point that's being made. So while Mr. Stafford's comments about the fact that any particular range of the state might only have 20 species, the fact is virtually every watershed in California would fall in the historic range of some or all of the species that are listed in Appendix 82, and thereby become subject to this very onerous regulation. We can go to the next slide. There are over 4,000 lakes and reservoirs in California. Of the 78 most popular vacation lakes in California, 2 are in excess of 100,000 acres. 14 are between 10 and 100,000 acres, 55 are between 1 and 10,000 acres, and 7 are between 5 and 100 acres. I give you that information just to give you a sense of the size of the areas that might potentially have to be assessed. In addition, there are over 20,000 registered ponds that would also be subject to these regulations. It affects all waters of the state, such as the majority of California lakes, reservoirs, ponds, golf course ponds, and backyard ponds that are stocked by either Fish and Game or by a private property owner. And as I said, virtually all of these would have potentially suitable habitat for at least one of the species that are identified in Appendix C. California anglers spent over $2 billion, freshwater anglers spent over $2 billion on recreational freshwater sport fishing trips and related equipment in 2008. So they're a huge part of the California economy. Can you go to the next slide? I think there's been a lot of discussion about what is the cost of doing these assessments. So a habitat assessment, which is the first step in the process, is something that if done by a private consultant would typically cost about $1,500 per 10 linear miles. So a number of these facilities could be done in one day of field work. These larger facilities that have up to several hundred linear miles of shoreline could take quite some time just to do the habitat assessment, which would be very likely to come back and say that yes, they have suitable habitat for some of these species, or 2, they're within the historic range of these species. That takes you to the next level, which is directed surveys. So the 8 problematic case studies that were referenced, those types of facilities then would take you into a cost of potentially $3,000 to $70,000 per acre, depending on the number of species that needed to be analyzed and the types of surveys that needed to be done. Many of these surveys are not one-day surveys where someone can just go out and take a look. They're either the state or through the California Department of Fish and Game or the U.S. Fish and Wildlife Service has set protocols for doing these surveys, many of which require multiple replicates of visits to make an absence or presence or absence determination. In the work that we did, we looked at 4 case studies, and there are only 4. I'm going to walk you through the 4. We're not by any means trying to say that this is a statistically significant sample. It's just to give you a sense of what would actually play out for a site of this nature that needed to undertake very specific surveys. The other points that I'd like to make on this slide is that there's no certainty provided once you've done the surveys. The guidelines as they're called out right now allow for the permit to be revoked during the 5-year period and require that they be reassessed every 5 years. So you're looking at a cost for doing these surveys that would be on a 5-year recurring basis. What we found of the 4 case studies that we did was that the average cost for doing the detailed surveys was $133,000, and all 4 of the case studies would have required detailed surveys to have been completed. So we can go to the next slide. We did look at 4 case studies. We tried to look at them in different parts of the state and a range of the sizes because of the large range in the size of water bodies in the state of California. They ranged in size from 2 to 579 acres. We looked at one in Orange County, Irvine Lake, very popular recreation fishing lake, Dixon Lake in San Diego County, Knickerbocker Lake in Placer County, Cape Breton Lake in Napa County. We characterized them based on the size of the lake, the perimeter in linear feet, the depth of the lake, whether they were a private or public facility, the associated amendments, a habitat assessment, and then the relation to historic range for decision species. So we can go to the next slide. This just shows you the distribution of the lakes and the sizes. We go to the next slide. So at Irvine Lake, it encompasses 579 acres. It's approximately 70 feet deep. It's stocked with trout, largemouth bass, catfish, crappie, bluegill, red deer, sunfish, sturgeon, wiper, and carp. Irvine Lake also has camping areas, launch ramps, a cafe, picnic and barbecue areas, and private boat and recreational vehicle storage, and a kids lagoon. Go to the next slide. Dixon Lake is a very large facility, 579.4 acres. It's approximately 70 feet deep. I'm sorry. And if we go to the next slide, Knickerbocker Lake is located at 8505 Knickerbocker Place. It is at 8.2 acres. It's approximately 13 feet deep, and it's located within the boundary of a private residence. It is not easily accessible to the public. Its known uses are for private leisure activities. We go to cake bread.
Ms. Campbell,
Yes.
Please remember that that your group has about 10 more minutes.
Okay, let me just go to the findings slide.
That
then.
was our agreement beforehand.
All right, so if we go to the findings slide, you'll see that the total cost in the far right-hand column ranged from $46,000 to do the surveys for an 8-acre lake up to $161,000 to do the surveys for Irvine Lake. So the size of the facility, the cost is not directly proportional to the size of the facility. Rather, it's directly proportional to its proximity to the historic range of the number of species which are potentially present. We go to the conclusion slide. So of the 4 facilities that we evaluated, the cost of the surveys would have, on average, have been $133,000. If that were applied to all 24,000 water bodies in the state of California, that would be in excess of $3 billion worth of survey work that would be required on a recurring 5-year basis. And even if you take a conservative estimate based on the information that Mr. Stafford just presented to you, that only 8 out of 120 facilities, or 8 out of 130 facilities, you'd still be looking at $300 million worth of survey work that we would require to support this program. Thank you very much.
Good afternoon, Mr. President and Commissioners. My name is Damian Schiff, and I'm an attorney with Pacific Legal Foundation. We represent the California Association for Recreational Fishing in an ongoing lawsuit in Sacramento Superior Court challenging the Department of Fish and Game's enforcement of many of these mitigation measures from the EIR as illegal underground regulations. And in particular, the department is currently enforcing illegally the Appendix K protocol that has already been discussed this afternoon. And later on this afternoon, one of the gentlemen who has had to go through the incredibly burdensome Appendix K protocol illegally in a non-exempt county will talk about his experience. In my short time, I simply want to emphasize one misunderstanding. And that is that the department is, I would respectfully submit, incorrect to say that this procedure is at all required by what went on in the Pacific Rivers Council lawsuit. You can look at the petitioner's complaint in that case. You can look at the court's ruling in that case. You can look at the judgment of the court and its order following judgment. And in none of those documents is there any reference to private fish stocking. And that's not surprising because private fish stocking at that time is not or was not a discretionary matter, in contrast to the department's hatchery policies and hatchery stocking, which was of course discretionary and therefore subject to CEQA. I should also mention that following this controversy, one of the plaintiffs in that original lawsuit, the Center for Biological Diversity, was quoted in the Riverside Press Enterprise newspaper as saying, "We never intended for our lawsuit to apply to private fish stocking." And as I mentioned, you can read the court's order following that case, its order modifying its judgment, in which it expressly exempts stocking pursuant to Fish and Game Code 15201. So I think it's clear that the desire to include private fish stocking in this process is something that has been decided upon by the department itself and is not at all mandated either by CEQA or by court order. And this commission should therefore refused to proceed with this rulemaking on the grounds that it is unnecessary and illegal.
Good afternoon, Commissioners. My name is Craig Elliott. I'd like to take this opportunity to speak before you and thank you. I'm an aquaculturist and recreational fishing lake operator, and I'm here today to ask you to oppose these regulations. The Department is trying to move forward the idea that the Commission can no longer exempt stocking in the 37 counties, and broadly states that Section 6400 requires that there must be a stocking for or permit for every stocking. However, it's not that simplistic, because as Commissioners, you know, you've thought out and implemented several well-reasoned exemptions under the Code. But first, we should remember and understand that the authority granted to the Department to regulate fish stocking is limited and circumvented. It's the Commission, not the Department, that is vested with the primary authority to regulate aquaculture products, including private fish stocking. Section 6401 states in part that any person under the regulations the Commission may prescribe may purchase or receive live fish from a registered aquaculturist and may stock such fish in any stream or lake. Moreover, the stocking of aquaculture products anywhere in the state into a registered aquaculture facility is exempt under the requirements of a fish stocking permit. Further, it's the Commission, not the Department, who may prohibit the placement of specific aquatic plants and animals in designated waters of the state, and whenever there's any provision of a code that that provides for a permit, an application, or an entitlement, it's the Commission who shall prescribe the terms under which that permit is granted, and it's the Department's job to issue it. The Department's authority is limited under the authority granted by the Commission, and denial of a stocking permit may only be made under limited circumstances. In particular, stocking may be made or denied if the stocking is of fish is contrary to the fisheries management program for the stock waters or drainage, or in any water from which a fish might escape, where it's not already present. Outside the authority granted by the Commission, the Fish and Game may not regulate private fish stocking permits. Here, Commissioners, the Department is trying to seize the opportunity to broaden its authority far beyond that which you've ever granted by means of using the Appendix K protocol of the Hatchery EIR for their new authority. The Department claims in the Hatchery EIR that the Appendix K protocol, quote, is designed to further clarify the Commission's regulations and the Fish and Game Code. However, Commissioners, any self-proclaimed clarification which tries to expand the limited authority granted by an agency is illegal under CEQA or any other law. Appendix K is an expensive multi-step decision process which will result in unknown, costly, and extremely subjective conditions being imposed on a private stocking permit or the denial of a permit altogether. Commissioners, the effect of these proposed regulations will be to give broad new powers to the Department and its staff, along with the subjective power to deny or condition any private stocking permits however they please, which will likely result in the stocking of one location and not the other under the same or similar conditions. Commissioners, this is bad. Please do not let this go forward. Thank you for your time.
Good afternoon. Noelle Kramers with the California Farm Bureau Federation. We represent over 75,000 members who will be impacted by this, and we appreciate the department's work on this, but have significant concerns about the impact on both our aquaculture farmers and our members who have farm and ranch ponds on their properties. The State Water Resources Control Board estimates a little over 20,000 registered or licensed ponds in California, and many of those are stocked. Our members stock them either for a small side business or more likely for recreational purposes for their families and employees. A rancher in California could need to obtain 20 different permits or comply with different regulatory programs to run their business. I cannot see any of them spending $1 or an hour even to obtain a permit for a fun activity. They have to spend so much time in addition to running their business to comply with California's numerous regulations that having additional permits for recreational activity is not going to happen. If you look at the critical habitat designation, just the red-legged frog has over 1.6 million acres designated. So any of our members in those 37 counties with critical habitat would then be required to have a significant survey done to make sure that there wouldn't be impacts to that species. So that is going to be incredibly costly, and our aquaculture members will be impacted, and our family farmers and ranchers who like allowing their kids and employees an opportunity to go out and fish will no longer have that. Thank you.
Thank you, Commissioners. If you have any questions, we're happy to address them.
Thank you, George. Any questions right now?